Hey everyone, this is Will Dungy and this is my first video. And for my first video, I will be discussing the Giammarino versus Derision of Taxation case. And I apologize if I mispronounced the last name. So this docket number is 001040-2024. It's an unpublished decision which was decided by Judge Novin of the Tax Court of New Jersey. Now this is a really long decision. I'm going to do my best to hit the important notes so that you don't lose interest in this video. And if you're already watching a tax video, I assume you either have a tax problem or you're interested in tax. So how did this opinion originate? Well, a non-party, the New Jersey Office of Legislative Services, was issued a subpoena, and in response to the subpoena, they sought a motion to quash. And essentially, the judge issued a decision regarding that motion to quash. The judge's decision revolved around interpreting New Jersey's speech or debate clause and whether information sought by the Office of Legislative Services was privileged. And so brief background of the facts. In early 2018, a number of bills were introduced to the New Jersey Senate and Assembly. And the pieces of legislation were proposed modification and amendments to the New Jersey Gross Income Tax Act. And these were about from January to April 2018. In May 2018, the plaintiffs sold their interest in their business, and it generated capital gains of approximately $316 million. So that was in May. In June 2018, Governor Murphy reviewed the bills and suggested a modest increase in income tax for multimillionaires before the bills were passed. And the Assembly adjusted the bills and included that provision where it would increase the tax rate on income over $5 million from 8.97% to 10.75%. And so this amendment was added into the bill in June 2018. The bill was essentially passed in July 2018, and it was applied retroactively beginning in January 1st, 2018. So essentially, this captured the sale of the plaintiff's business interest. And when the plaintiffs sold their business, this wasn't law. And now, a month after they sold, it became law. And whether or not they knew that this provision was going to be included in the bill, would they have sold their interest? I don't know. Were they actually paying attention to the bills? I'm not sure, but if you're dealing with this type of money, I'm sure you're a little interested in any new tax updates. So obviously the plaintiffs began to contest actually before they were contesting, plaintiffs filed their 2018 income tax return and just, reported their gain of their business interest and remitted the 10.75% tax on their gross income. The following year, in October 2020, the plaintiffs filed an amended 2018 return seeking a $5.5 million refund based upon the retroactive application of the 10.75% interest rate that was assessed on their income over $5 million. So in 2021, as you would expect, the Division of Taxation denied the plaintiff's refund claim. Plaintiffs filed a timely protest. And in February 2024, the protest was denied. A final determination was entered in November. And then in February 2024, the plaintiffs filed a complaint challenging the director's denial, basically asserting that the increase in tax after the sale of their business was manifestly unjust, discriminatory, and violates their due process and equal protection rights. And so shortly, about a year after they filed the complaint, the plaintiffs' counsel issued a non-party subpoena to Mr. Neville, legislative counsel to the OLS, Office of the Office of Legislative Services. Now, this was an interesting move by the plaintiff's part, and I'm not mad at it. I think it was pretty good. And so, in support of its motion, before it got to the motion, the OLS actually responded to the subpoena saying all this information is privileged. Go kick rocks. And the plaintiffs responded to that, privilege assertion saying at the bare minimum, you have to produce a records log and saying what is privilege and why it's not privilege. Now, the documents and information that plaintiffs were seeking was, testimony from Mr. Neville, all documents that refer or relate to communications regarding the plaintiffs, all documents that relate or refer to the specific amendment of the Gross Income Tax Act, and all documents that refer or relate to any communications or discussions regarding the governor's proposed amendments to the act. So later in March, obviously the OLS denied their request, and finally September came. Plaintiffs said, if you don't respond and produce the privilege log by September 30th, it's do this or else. And so instead of abiding by the plaintiff's request, the OLS, instead of responding to the plaintiffs, filed a motion seeking to quash or dismiss the subpoena. And in support of its motion, the OLF emphasized that it is an established in the legislative branch of the state government to aid and assist the legislature in performing its function, and maintained that the speech or debate clause precludes discovery in private civil litigation seeking to compel production of non-public legislative documents. In response to this motion, the plaintiffs maintained that the immunity granted under the speech or debate clause is not, a blanket privilege, and rather the protections afforded are only to legislatures that are acting in an integral part of the deliberative or communicative process. So the plaintiff essentially wanted the court to go on a fact-specific analysis to discern if the activity was casually or incidentally related to the legislative affairs, but not a part of the legislative process itself. And essentially, the plaintiffs were saying, listen, all we want is to have the OLS produce a Vaughan index and have the court decide what documents can be produced and what documents can't be produced. And which is a good call. I think, putting it in a judge's hands on this type of information is always a good call, because you're not allowing the judge to just immediately release records. But if you think you have a good case and you think the judge might agree to some of the stuff, then let them look at it, and you can put your best arguments onto why something might get produced. So the court's analysis is simply that is the subpoena so narrowly tailored and limited in scope that it would exclude production by the OLS of any documents that are an integral part of the legislature's deliberative and communicative process. If the court finds that it is, then the subpoena should be upheld. But if it's broadly written and demands production of anything and everything, then the court bears an obligation to attempt to segregate and closely scrutinize the information sought. So basically, the court found that contrary to the OLS's argument, there is no blanket wholesale immunity afforded to the production of that they don't have to produce any documents. And in the court's review and analysis of the plaintiff's subpoena, the court did find that it was broadly drafted and sought certain information that was unmistakably within the legislative sphere and legitimate scope of legislative activity. But the subpoena may also yield information related to political conduct with communications with non-legislative bodies not related to the business before it. So the court basically did what the plaintiff requested and going fact specific on which document sought is discoverable or not discoverable. And there was a lot of requested documents. So in short, basically paragraphs 2 through 9 of the plaintiff's subpoena was kind of disregarded, and the court granted the OLS's motion to quash and dismiss these paragraphs. However, the reason was because they were within the legislative sphere and insulated from disclosure. But paragraphs 10, 11, and 12 sought documentation and information with respect to the legislative fiscal estimate and how it derived the estimated additional revenue. And I think this is interesting, and I think the underlying issue in the plaintiff's case was that they think that this amendment was specifically added because the government knew of their sale and they wanted to tax it. So, and whether that information was used in deciding the fiscal estimate. And when I say it was granted, 10, 11, 12 were granted in part and denied in part. My apologies. And so the motion was granted insofar that, any information that relate to the, increased tax rate under Assembly bill will yield additional revenue, and that relate to the estimate of additional gross revenue derived from the statistics of income published annually. Essentially, this information was highly, political, and it's part of the legislative process, so it's protected by the privilege afforded under the speech and debate clause. But the motion to quash was denied insofar that the OLS needs to produce documents or communications that it possesses that were provided informally by the executive branch. And the issue is, what does informally mean here? Discussing in the hallways, did it have to have a specific stamp on it? I'm not sure what the court means when information was provided informally here. And I'm not sure, but this might be something that might be litigated in. And so essentially everything that wasn't protected needs to be produced. However, the judge gave OLS a way out, saying, hey, if you think any of these documents should be limited or protected, then you need to produce a Vaughan index and give it to me so I can be the ultimate decision maker. And I think here the OLS will go under this route before they just issue documents. But you never know. And so here, and also, they also tried to seek testimony from Mr. Neville. And if you didn't know, Mr. Neville is the chief legal officer of the New Jersey legislature. And basically his conduct is wholly legitimate legislative activity when it comes to producing bills and discussing. So the court denied the request for testimony. If you find this information relevant to your world, please do not hesitate to contact me. You can look me up. My email address is wdungy@colzerdpadova, and I'm happy you watched this video. Have a great day.